The Supreme Court Constitution Bench delivering its judgment on the scope of freedom of speech and expression for lawmakers and political representatives. The question is, should there be a written code of conduct for the legislators? Can right to free speech and expression, especially for those in public office, be curtailed by the right to dignity? Nilashish on the broadcast with us. Nilashish, very crucial verdict from the Supreme Court. The fundamental rights must be protected. One of the observations that has been made by the top court.
Well, Pratibha, a very significant judgment coming in from the Supreme Court, where it has been held that no additional restrictions other than the ones prescribed already under the Constitution, which is under Article 19(2), can be imposed on, in terms of free speech, on legislators, on MLAs and MPs, on leaders. It is said that other than the rules prescribed in the Constitution, there can be no other additional restrictions that can be imposed on the right to free speech of a citizen. And it says that the restrictions under Article 19(2) are in fact exhaustive. Very significantly, what the court has said here is that state is under a duty to affirmatively protect fundamental rights of a citizen, even in the violation or by a non-state actor. And the statement made by a minister related to the government or its affairs cannot be vicariously related to that of the government. Also, it has been stated that a mere statement by a minister inconsistent with the rights of a citizen does not form to be a constitutional tort, but if it leads to omission or commission of an offence by a public official, then it is a constitutional tort. Now, very significantly, what the judgment basically is that as far as legislators are concerned, there cannot be any additional restrictions to their freedom of expression, to their freedom of speech. Whatever is there in Article 19(2) of the Constitution, that is sufficient to, in fact, curb any sort of violations or any sort of reasonable restrictions that are to be put on freedom of speech and expression, even in the case of legislators.
Okay. In fact, the court also holding that the statements that are being made by a minister related to the government and its affairs cannot be vicariously attributed to the government. So the freedom of expression, in a sense, to those who are in public also being just the same as for any other citizen, Nilashish. All right, apologies. Before I come to you, just want to bring in Mr. Swapnil Kothari, Supreme Court advocate, on the broadcast with us. Mr. Kothari, very big ruling that has come in from the Supreme Court. No additional restrictions other than those that are already prescribed for the other citizens.
Well, absolutely. I mean, I don't see any difference between any other citizen and political people, except that you may say that morally you might be a little bit more conscious when you say something, because you have, since you're a politician or a legislator, you have a little wider reach or a wider impact, just as it would tell another film star or anybody else more in the public domain that, look, you know, you shouldn't have made this statement. Rather, you should have exercised a little bit of restraint when you made this statement, because your statement carries a lot of weight. That's about it. And that is what all you can say as a court to anybody morally. But other than that, legally, you cannot restrict someone, because there is no prescription in the Constitution saying that for politicians or legislators, there is another set of restrictions as opposed to for you and me as common citizens. So obviously the Supreme Court has come out with something which is absolutely doable and which is something which is within the parameters of the Constitution. And the Supreme Court, obviously, as you know, under Article 141, the law laid down by the Supreme Court is considered to be the law of the land. So this will be the law of the land now, as it was earlier also in terms of statutory 19(2), which prescribed the restrictions, and now it's just enhanced the scope of 19(2), or enhanced or rather explained the scope of 19(2), saying that it's all the very same for even politicians and legislators. So I think this is a very good ruling, and I'm glad that one after the other, when the in the new year when it opens up, yesterday also it did not say anything against demonetization procedure, that it was fine. Today has come out with freedom of speech. I'm glad that the Constitution benches are delivering the judgment as they are supposed to be, and finally putting anything to rest. If anybody had even a shred of doubt, we never did. Neither of any of our senior advocates ever did that, or even advocates for that matter, that the Supreme Court is the final arbiter and the protector of the Constitution. So hats off to the Supreme Court once again, and salute from this officer of the court to the highest court of the land.
Okay, so the statement that had been, made by the Supreme Court saying that anything that a minister says related to the government or its affairs cannot be vicariously related to that of the government. But there was a differing view as well on freedom of expression versus hate speech and, the thin line between that. So where does this Supreme Court judgment now place that?
Well, I think obviously there is a vast difference between freedom of speech and hate speech. I mean, I can say as many conflagratory things against a particular religion or anything of that sort, but to the conflagratory in the sense that I may dislike certain aspects about certain religions and I'm free to vent them out, but not to the extent that they can be conflagratory in the sense that they can get people on the streets to rioting and all of those things. Those are called hate speeches, or that they tend to disrupt the communal harmony, because ours is a secular republic, and we are a mixture of several religions. So obviously there the Supreme Court is definitely going to put its foot down and say that, sorry, freedom of speech, yes, but hate speech, no, because that again is proscribed by under 19.2, proscribed. So I'm using the word proscribed, meaning banned, as far as public order morality is concerned. So obviously the public is going to be in disorder if there is going to be any hate speech. So definitely the politicians have to mind that, and that legally they have to mind that, not morally. Morally is a separate issue. Legally also they'll have to mind that, otherwise they'll be caught within the net of Article 19.2, and they could possibly be, even hauled up for that.
Okay, all right. Mr. Kothari, thank you for joining us on the broadcast with your views. The Supreme Court ruling that no additional restrictions other than those already prescribed can be used for those who are in public office.